Good morning. Wait until people have had the chance to join, and then we'll begin. Welcome to the Supreme Court Review Panel for the 2021 Alumni Reunion. I wish so much that we could be in person this year, but safety and health cautioned against that and caused us to again be online. Look forward to next year when we can have an in-person reunion, and welcome back all of you and all who celebrated reunions last year where it also had to be online. My name is Erwin Chemerinsky, and I'm incredibly fortunate to be the Dean of Berkeley Law. It's an amazing time in the United States Supreme Court. Shortly before last year's reunion, on September 18th, 2020, Justice Ruth Bader Ginsburg died. Soon after last year's reunion, on Monday, October 26, 2020, Justice Amy Coney Barrett was confirmed. It's often been said that every time there's a new justice, it's a different court, and there have been 3 new justices in the last 4 years: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Justice Barrett didn't participate in the October 2020 oral arguments. She participated in the oral arguments beginning in November. The Supreme Court last year decided only 54 cases after briefing an oral argument. That's the second fewest number since 1862. The only term that was less was the year before, when it was 53 cases. And so we didn't get that many months or that many decisions to get a sense of Justice Barrett. This will be the first full year on the court where we have Justice Barrett and the full complement of justices. And by any and all measures, it's going to be a blockbuster year in the United States Supreme Court. And we have a terrific panel to discuss the cases. I'm going to briefly introduce them to you, then describe our format for the morning. And I apologize to the panelists that my introductions are going to be very short, because I could spend all of our time this morning just telling you their amazing accomplishments. Introducing them alphabetically, Easha Anand is a 2014 graduate of Berkeley Law. She clerked for Judge Paul Watford on the Ninth Circuit and Justice Sonia Sotomayor on the United States Supreme Court. She's now the Supreme Court in Appellate Counsel in MacArthur Justice Institute. She especially focuses on criminal law issues, representing criminal defendants, handling death penalty and habeas cases all over the country. Delighted to welcome her back again to our Supreme Court Review panel. Jennifer Chacón joined our faculty on July 1st of this year, and I'm just thrilled to be her colleague again. Jennifer is a graduate of Yale Law School, clerked on the Ninth Circuit for Judge Sidney Thomas, had a distinguished academic career being a tenured professor at UC Davis Law School, UC Irvine Law School, and most recently at UCLA Law School. She specializes in constitutional law, immigration law, criminal procedure. We'll be teaching all of those classes here at Berkeley. And Professor Orin Kerr joined our faculty just a couple of years ago. He's now in his 3rd year with us. Professor Kerr is a graduate of Harvard Law School, clerked on the 3rd Circuit, and then for Justice Anthony Kennedy on the United States Supreme Court. He had a distinguished academic career for many years at George Washington University Law School, and then the University of Southern California Law School. He's thrilled he joined our faculty. He teaches criminal law, criminal procedure, computer crime, among other topics. So even from this short introduction, you can see we have terrific people this morning to discuss the United States Supreme Court. Here's how we're going to go about it. Each of the panelists will offer some opening thoughts about the Supreme Court, where it is now and where it's likely to go in the foreseeable future. Then each panelist will take one case from last term that he or she believes to be particularly important and discuss it and why it matters. Then each panelist will take one case from the coming term, begins week from Monday on October 4th, and talk about why it matters, perhaps what to expect. We'll then save time for questions. There is a handout that I prepared for CLE purposes. It gives a summary of the major cases from last term, including the ones we're going to talk about, but many more as well. Also, we're going to welcome questions and discussion from you. We'll save time at the end for that. Please use the Q&A function for your questions, and then I'll be able to pose them to the panel. So with huge thanks to Easha and Jennifer and Orin for taking part of their Saturday morning to do this, let me start with Easha and ask, what are your overall thoughts on the Supreme Court?
So thank you so much, Dean Chemerinsky, and thanks again for having me here. I think this is my 5th year doing this, and it's always such a pleasure, and particular honor to be alongside Professor Kerr and Professor Chacón this year. So I wanted to just spend a few minutes talking about the kind of 3 big consequences I see of the shift from a kind of 5-4 to a 6-3 conservative majority court. It's going to mostly be bad news if you sort of are in my line of work or have my political priors, but there's sort of some good news that I'll try to spotlight along the way. So the 3 big consequences I see, the kind of first one is liberals have lost their ability to kind of set the agenda. So even when they were for liberals, the one thing they could do was force the court to grant cert, right? And in the sort of 10,000 or so petitions that come to the court every year, there are often several, sometimes dozens of cases where if the justices are really forced to cast a vote, they will probably side with the non-citizen or the criminal defendant or whatever the case may be. So that would happen in cases sometimes about kind of very individual unfairness. I'm thinking in prior terms, there were cases like Foster, which is a sort of Batson case where the prosecutor literally highlighted the names of all the Black jurors in the veneer, or Buck, where an expert witness testified that certain races were more dangerous than others, or more recently Flowers, a case that took 6 tries to secure a conviction and where the prosecutor struck Black jurors at every stage. Or just there's sort of mine run, there's a split among the courts of last resort, and we're going to take it up. And actually, the text of the relevant statute is pretty clear. This is probably going to be unanimous if we're forced to reckon with it, but we need 4 people to force us to do that. And so my prediction is that the docket we're seeing this fall, which has a particularly sort of high concentration of conservative on top, high political salience cases without necessarily a split in authority, I don't think that's going to be anomalous going forward, because it's often been the 4 liberals who would reliably force the court to allocate its time to these sort of below the radar, but really important for the person being kind of imprisoned or deported kinds of cases. So that's kind of consequence 1. The second is, in past years, the fact that the conservatives on the court were sort of different breeds, right? That you had, Justice Thomas, true blue originalist, and Justice Gorsuch, who had a sort of libertarian streak, and the Chief with his institutional streak. That was an asset for liberals, right? Because if you needed to pick off one conservative, it was helpful to have one bucket of cases where it would be Justice Gorsuch, and a second bucket where it would be the Chief, and a third bucket where it might be Justice Thomas. Now that you need to pick off 2 conservatives, that's a liability, right? Because actually the Venn diagram between these different camps is not huge on these sorts of crossover issues. So I think that's the sort of second consequence I kind of predict going forward is, whereas you used to see these kind of 5-4 cases in the past few terms where someone crossed over to join the liberals to reach a liberal outcome, one crossover just isn't enough anymore, right? So even when Justice Gorsuch or the Chief crosses the aisle, that's not going to do the trick. So that's sort of second consequence. And then the third thing I've just been sort of thinking about a lot this past term is what it means that Justice Kavanaugh is kind of growing into his role as swing justice. And again, that's not precisely right for the reasons I said, right? There are different kinds of cases where different people might cross over. But on this sort of generally accepted political spectrum, on the kind of generally politically salient cases, it's going to be Justice Kavanaugh, right? The chief doesn't make 5 anymore, it's Justice Kavanaugh. And in that respect, I think 2 cases this term that Justice Kavanaugh authored. One is called Edwards versus Vinoy, which is about the retroactivity of a case holding that criminal convictions have to be by unanimous jury, even in state court, and Jones versus Mississippi, which is a juvenile life without parole case. I think that pairing is really fascinating and kind of important for progressives watching the court. And that's because it shows the ways in which Justice Kavanaugh, who authored both of those decisions, has a little bit of a wild card when it comes to stare decisis and precedent. So in Edwards, no one had asked the court to overrule a kind of branch of retroactivity jurisprudence. And in fact, it wasn't necessary to do that to reach the outcome of the case. But Justice Kavanaugh's opinion kind of goes ahead and reaches out and does that anyway. And then Jones, conversely, a lot of people have thought that that case is really inconsistent with prior cases about juvenile life without parole issues. In fact, Justice Thomas writes a concurrence in that case and is like, why don't you just overrule those cases? What you're saying here is so impossible to square with them. But Justice Kavanaugh goes to these great pains to say, actually, I'm just very carefully following precedent. I just sort of read between the lines. And I think that interesting pairing of sometimes being the sort of legal arsonist and saying, precedent's kind of a thumb on the scale, but if you think it's no longer serving you well, reach out and overrule it. And sometimes taking this very Chief Justice Roberts position of, no, don't worry, we're really carefully following the letter of the law. I think it makes him a sort of difficult one to predict for the progressive. So there's a lot more I could say, but I'll sort of stop there. And I'm curious to hear others' thoughts about this shift this term.
Jennifer?
Thank you so much. Thank you for the invitation to be here to join this erudite group. I'm really honored. And I also want to acknowledge my debt to the Ohlone Nation and the other descendants of the Verona Band on whose ancestral lands I live and work. In preparing for this panel, I've been thinking a lot about Professor Nicholas Bowie's June 30th, 2021 statement to the Presidential Commission on the Supreme Court of the United States. That was President Biden's commission to study the current functioning and possible reform of the court. And Bowie opened by recounting Alexis de Tocqueville's observation in the 1830s that the judicial branch and the legal bar are the US aristocracy, people who view themselves as a, quote, privileged class among intelligent people because of the, quote, special knowledge that jurists acquire while studying the law. And de Tocqueville thought that this extraordinary power of the judiciary and extraordinary deference to it were actually problematic deviations from other structural institutional commitments to democracy. So in his 2021 testimony before the commission, Bowie charted many of the anti-democratic interventions of the US Supreme Court in the time since de Tocqueville, from its reification of slavery in the Dred Scott case in the 1850s, to its gutting of democratically enacted, constitutionally authorized voting rights legislation in its 2013 Shelby County decision, with a lot of examples in between. Their actions have obviously made the Supreme Court a very powerful institution, but Bowie contended it also has the effect of weakening democracy. So we can think now about what happens in our federal political system, where we watch enacted or elected legislatures in Congress frequently punting, whether deliberately or because they just can't do anything differently, punting on important issues of the day, from immigration reform to climate justice. The process of enacting laws in this country is difficult by design. It's supposed to be hard to make law, but our constitutional structure obviously makes it even harder. And there are anti-majoritarian tendencies that have sort of been amplified in recent times. So we can see that in the Senate, there are 50 Democrats and 50 Republicans. That sounds pretty balanced, but those 50 Democrats represent 41 million more people than Republicans, the Republicans do. And Senate rules and the filibuster ensure that we need senators representing an overwhelming supermajority to pass most legislation. So if we think about sort of how legislation is passed and how legislation is struck down, we can see that you need 60 votes in the Senate to make law, but you need 5 votes from a wildly non-representative Supreme Court to strike down those laws. So that's the balance that we've struck right now. So it's perhaps no surprise that when unintended or untended issues in our nation erupt into crisis or are opportunistically labeled as crisis, this gets worked out in a power struggle that often doesn't involve Congress. The executive branch and the Supreme Court are tossing these issues between themselves. When there's a Republican president, it's a friendly joust sometimes between the executive branch and the Supreme Court. And the last word goes to the court, where 4 of the justices were appointed by presidents who didn't even win the popular vote. So we have a Supreme Court that matters a lot. We have a system where it's hard to enact law. We have a system where the Supreme Court that matters a lot can strike down laws with some ease. And that's why this event matters. That's why we're here on a Saturday when we could be out of the sun, right? The court matters a lot and does a lot of important things. And so I think one of the things I wanted to do with my framing remarks was just to throw that out there and emphasize that it matters. This event matters. It matters that we talk about these things, but it also should make us question how important these events have become in diagnosing the state of our nation, and have us asking some hard questions about the structural underpinnings of our political system and the role that the court is playing in it. So I hope those issues will be on the table in our discussion today as well.
Thank you. Orin?
Thank you. It's delightful to be here with such wonderful colleagues and friends on the panel. It's really great to be here, and I wish we could all be here in person, but this is at least we can still communicate, if not be in the same room. So this is a great and important topic, and I wanted to offer a couple of broad stroke perspectives on where we are in terms of the Supreme Court. For my lifetime, I'm 50 years old. For my lifetime, the U.S. Supreme Court has almost that entire time had a center vote that was roughly in the center of American politics. And so that would have been Lewis Powell for many years, and then Justice O'Connor for many years, and then Justice Kennedy for many years. And to the extent the U.S. Supreme Court, in the cases that most people really care about, which is usually the big kind of political or culture wars debates kinds of issues, to the extent the U.S. Supreme Court will often kind of track the politics of the justices, as Easha pointed out. You know, there's a rough political narrative, which doesn't tell everything, but it's a pretty decent guide, unfortunately, for where the Supreme Court's going. For decades, the U.S. Supreme Court has been kind of in the slightly right of center, but actually fairly reflective of American politics position, I think, in terms of that, in that swing vote. And that has really changed. For a while there, we had Chief Justice Roberts as that kind of center vote. The vote needed to get to 5 votes, and he's considerably more conservative than Justice Kennedy, but also fairly institutionalist, which made him kind of a little bit more centrist in maybe in practice than in sort of first principles. But now we've moved on to a world where the center vote is, as Easha pointed out, probably in most cases Brett Kavanaugh, who's very conservative. Very conservative. A Supreme Court where Brett Kavanaugh is the center vote is something that you kind of couldn't have imagined 10 years ago or 20 years ago. I remember when Brett Kavanaugh was nominated to the DC Circuit, and there was a sense of, wow, he is so conservative. Is he going to get confirmed? He's so conservative. And now he is the center sort of 5th vote in U.S. Supreme Court cases. It's kind of hard to imagine sort of, you know, have we had something like that with the politics reversed? Maybe, I think probably the Warren Court for a few years there. There was a, 1963 maybe to 1968, we had that kind of center vote being relatively far from the sort of American political center. But it's really rare. And so I suspect what that means is we're going to see significant movement on the kind of culture wars cases that a lot of people care about, the issues like abortion and affirmative action and Second Amendment and kind of the front page of the New York Times kind of type cases. You're going to see significant motion because for the first time in a half century, there's a U.S. Supreme Court that has a significant sort of clear majority on one side of these hotly disputed issues, and I suspect that majority is going to wanna take some significant turns in the law as a result of that. So there's that part of it. I think we're going to see significant changes in those issues. To my mind, the kind of more open question is how much change are we going to see in other areas of law? So much of what the Supreme Court does is not the super high profile, front page of the New York Times kind of cases, whether it's interpreting a criminal statute or interpreting many others. Half the cases roughly are going to be statutory cases. And then a lot of the constitutional cases are going to be fairly on small issues. And where's the Supreme Court going to go on those cases is something that I think is probably more in doubt, at least when I think about it, than how it's going to go in the really big culture wars type cases that are going to be on the front page of the paper. And here I think that it is less predictable because the justices have less invested in a lot of the smaller cases. And the rise of originalism actually creates some really interesting coalitions that might be emerging because there are some areas in which there are kind of politically progressive positions that have a plausible originalist perspective and justices who, with strong commitments to originalism, where they may not have a sense of where it plays out. And I always think back of Justice Scalia's kind of interesting turn relatively late in his career when he started to reach sort of quote unquote liberal results in a bunch of cases on originalist grounds in fields where he probably didn't care very much, like criminal procedure, which is what I do and a bunch of us on the panel do. And I always thought what Justice Scalia was doing was sort of like anything to show that his originalist methodology was real. To the extent it reached a result that he might not like, there was sort of a like, ha, this is real kind of part of it. It was like sort of showing the methodology has significance. And I suspect there's more where that came from in terms of some of the justices on the court that may be open in terms of where they're going to go based on different arguments that could be raised. So I suspect you're going to see a lot of originalist briefing on the Supreme Court, and that methodology is going to be sort of everywhere. And I think we've almost reached that point already, and we're going to talk about some cases I think that raise that. But I think there's much less predictability in where the court is going in the low profile cases, and there may be a much more mixed court in that area as compared to the kind of culture war high profile cases where I do expect we'll see a significant turn to the political right in terms of the valence of the cases the court decides.
Thank you. Each of the panelists has been talking about what does it mean that there are on the current court 5 staunch conservatives in Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, 1 moderate conservative in Roberts, and just 3 justices left of center when you talk about Breyer, Kagan, and Sotomayor. I think statistics help us to see what was the effect of Barrett replacing Ginsburg. 2 years ago, in October term 2019, Justice Ginsburg's last on the court, as I said, the court decided 53 cases with signed opinions after briefing and oral argument. 14 of them were 5-4 decisions. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. Everything we know about Justice Barrett, from her writings as a law professor, from her time on the Seventh Circuit, from her months on the Supreme Court, she's likely to be very conservative. So these cases in all likelihood would have been 6-3 rather than 5-4. The margin would have changed, but not the result. But there were 2 cases that were 5-4, where the majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. They were important cases. One struck down a Louisiana law restricting access to abortion. The other said that President Trump had acted illegally in rescinding DACA, the Deferred Action for Child Arrival program. Again, based on everything we know about Justice Barrett, had she been on the court rather than Justice Ginsburg, those cases would have come out differently. I made 2 predictions beginning of last term after Justice Barrett's confirmation. We would see a lot more 6-3 decisions because there are 6 justices appointed by Republican presidents who are quite conservative. And that's what turned out last year. Last year, out of the 54 cases, 12 were 6-3 and 6 were 5-4. Also, I said we'd see very few cases that were 5-4 with the liberal just the majority. Easha explained why. And it's simple arithmetic. It's much harder to get 2 votes than it is to get 1. And indeed, last term, there were no 5-4 decisions that were ideologically defined where the liberals were in the majority. I think what I would say as we begin this discussion is that this isn't a short-term phenomenon. Amy Coney Barrett was 48 years old when she was sworn in on October 26th. If she remains on the court until she's 87, the age of Justice Ginsburg when she passed away, Barrett will be a justice into the year 2059. Neil Gorsuch was 53 on that day, Brett Kavanaugh 55, John Roberts 65, Samuel Alito 70, Clarence Thomas 72. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. Justice Stevens didn't retire until he was 90. So it's easy to imagine this group of justices, at least 5 of the 6 being for the next decade or 2. So it's not just a conservative court for last term and this term. It's a very conservative court for many years to come. And I think we can see that if we begin focusing on specific cases. We'll start with last term, and Jennifer is going to talk about Brenovich versus Democratic National Committee.
Thanks, Erwin. So yes, I wanted to talk about Brenovich, looking backward. And so this is a case that involved a Voting Rights Act challenge to 2 Arizona voting laws that were brought by the Democratic National Committee. So one of the challenge provisions involved an out-of-precinct policy that requires election officials to throw out the entire ballot if it's cast in the wrong precinct. So if the voter's name doesn't appear on the voting rolls at a particular precinct, they're allowed to cast a provisional ballot, but if the election official later concludes that they voted in the wrong place, the entire ballot is discarded, even the votes for statewide or national office where the precinct doesn't actually matter. The second provision makes it a felony to collect and deliver another person's ballots, with some limited exceptions for family, mail carriers, and elected officials. So the DNC challenged both of these provisions, arguing that they violated Section 2 of the Voting Rights Act. Now, as you'll recall, in 2013, the Supreme Court took another Voting Rights Act case, in that case involving a challenge to Section 4B of the Voting Rights Act, finding an affront to the dignity of states in Section 4B's identification of certain jurisdictions to Department of Justice pre-clearance requirements for changes to their voting laws. Because they struck down Section 4B, which had kind of the method for determining which jurisdictions would be subject to pre-clearance requirements, this effectively mooted the pre-clearance requirements of the Voting Rights Act. So there's no longer a need for jurisdictions to pre-clear with the federal government changes in their voting procedures after Shelby County. So now, if you have a change to voting procedures that looks discriminatory in some way, the way to challenge that is through Section 2. So you have to litigate it based on the changes to the law. So Section 2 of the Voting Rights Act prohibits racial discrimination in voting. It's obviously harder to activate than Section 5 because you have to do it on the back end as a litigation challenge rather than asking for clearance of it on the front end. With its decision in Brenovich, the Supreme Court substantially weakens Section 2 as well. So in the Brenovich case, there was evidence that the Arizona voting laws at issue had an adverse and disparate effect on the state's Native American, Latina, and African American citizens in their voting in violation of Section 2. And there was also some evidence that these laws were enacted with the intention of suppressing the votes of these groups. Nevertheless, we had Justice Alito writing for 6 conservative justices holding that these Arizona laws did not violate Section 2. His decision doesn't actually provide a sort of exhaustive list of factors that have to be considered for a Section 2 violation. He says it's not exhaustive, but he instead sort of lists a number of considerations that were brought to bear in this case in declining to find a violation. So he looks first to the size of the burden imposed by the law, finding it here, the burdens that the laws here impose were mere inconveniences. He looks to the extent to which the practices differed from the law in 1982 when Section 2 was amended. He says it was harder to vote in 1982, it's easier to vote now, so our assumption should be that the procedures now are fine. he looked to the severity of any disparate impact on a particular racial or ethnic group. So the mere fact that there is a disparate impact, which there was in this case, is insufficient. There has to be a big enough disparate impact. And although the court doesn't quantify what that looks like, it determines that Arizona's disparate impact is not enough to constitute a Section 2 problem. Fourth, he looks to the state's overall voting scheme to see how generous it is, and finds in this case it's a generous voting scheme. And finally, looks to the reasons that the state enacted the law. So here, notwithstanding record evidence of discriminatory purpose, Justice Alito credits the state's stated purported concerns with voter fraud and says the state has a legitimate reason to act here. And so the laws are not a violation of Section 2. So that was the 6-justice majority. Justice Kagan dissented on behalf of the 3 remaining liberal justices, reminded the readers about what had already happened in Shelby County in 2013, the demise of Section 5, noting that the only operative Voting Rights Act protection for discriminatory voting really is Section 2, which, unlike Section 5, does require litigation on the back end. And she notes that what the court has done with the Brenovich decision is made those kinds of litigation challenges basically incredibly difficult to mount, even where you do have evidence that the voting laws are discriminatory. So what we're left with post-Brenovich is a Voting Rights Act that after Shelby County and after Brenovich has been substantially hobbled, which is why we're seeing so much discussion on the Hill about the need to pass additional voting rights protections, which unsurprisingly have not gone anywhere yet. So that's where we are with the Voting Rights Act.
Thank you so much. Orin, you wanted to talk about VanBuren?
Yes, so the case I wanted to discuss is VanBuren versus United States. It's a case about the federal computer crime statute, a law called the Computer Fraud and Abuse Act. And the Computer Fraud and Abuse Act, also known by its acronym, CFAA, was enacted in the 1980s, back when most people maybe started to get personal computers, but nobody was using email, or the web didn't exist, and computer networks were something that maybe you used if you were in government or in national security or a scientist of some kind. Congress enacted this law to prohibit computer hacking. And you can imagine this is sort of the Matthew Broderick hacking into computers in the movie War Games, for those of you that were remember that movie from the 1980s, formative experience for me. But the Congress was worried about computer hacking, and they drafted a statute that prohibits unauthorized access to computers. And they prohibited specifically accessing a computer without authorization, and then exceeding authorized access to a computer. And the question was, what does this statute cover? Now, in the 1980s, this was an important question if you happen to have computer networks, but most people didn't. In 2021, this is an incredibly important question because everybody is using networked computers all day long. You're on a networked computer right now. When you woke up this morning, you probably checked your email, accessing many networked computers. And so we now live a world in which we are constantly using computers. And the US Supreme Court had never weighed in on this question of what counts as an unauthorized access to the computer. Lower courts had divided on this question, really because there are different ways in which you can have an potentially unauthorized access. One is the actual hacking in. Think like, you want to access someone else's private account and they have a username and password. You might guess their password in order to try to get into their account, or hack in somehow by exploiting some sort of security flaw. But we also have accounts that we are given that are governed by, for example, terms of service, or employment policies, or some sort of condition written on or told that we are told, like, don't use your network or account in this particular way. And the real question in VanBuren was whether the Computer Fraud and Abuse Act is limited to hacking in, or whether it also covers using a computer in a way you're not told to use the account that you have. So Mr. VanBuren is a police officer who is given an access to a sensitive law enforcement account. He then accepts a bribe to look up information in the account for a few $1,000s to help someone in his town. It turns out it's part of an FBI sting. And he is charged with first bribery for taking the bribe, but also with unauthorized access, and specifically exceeding authorized access to the computer, on the ground that he was told only use this network for work-related reasons, and actually he used the network for personal reasons or for non-official reasons, that is, for looking up information as part of this bribe. And the U.S. Supreme Court splits 6-3 on whether this is a CFAA violation. The majority opinion by Justice Barrett takes the view that the facts of VanBuren are not a violation of the Computer Fraud and Abuse Act. Justice Thomas, joined by the Chief Justice and Justice Alito, would have concluded that it is a violation of the Computer Fraud and Abuse Act. Most of the analysis of the two opinions, interestingly, takes a very textualist form. And so here it matters that the definition, the term exceeds authorized access is defined as, and I'll just read the statute here, to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. Now, I hear that definition, and I think that is completely circular. It just says you're not entitled to do what you're not entitled to do, not answering the question of how are you entitled. Well, the U.S. Supreme Court writes 37 pages of opinions which focus on the word so, because the parties raised this to the Supreme Court as the entitled so to obtain or alter, that the word so has the magical answer to this particular question. Majority concludes the word so does not really change the nature of the prohibition. The dissent would say that the word so does change the nature of the prohibition. What's interesting and important about VanBuren is, first, it rejects the most broad interpretations of this statute, which is a good thing, because if it, under the dissent's view, all of us are violating federal criminal law every day because we're always violating terms of service, and any computer that says, you know, only use this a particular way and then you use it a different way, or, you know, I can set up a website and say only use my website if you are right-handed and you're left-handed. Sorry, you violated the Computer Fraud and Abuse Act. You can now be arrested and prosecuted. And so the fact that the court took a narrower approach to the statute is a good thing, because it means that we're not all committing federal computer crimes all day. But the court also doesn't quite answer where the line is. The court says that the statute implies a gates up or down inquiry, and it comes close to saying that hacking in is required, some sort of circumventing a code-based restriction, that is sort of breaking in or seeing something you're not allowed to see or that's blocked by some sort of an authentication gate, like a password gate. The court says a lot of language that hints at that, but then in a footnote says we're not answering that question, leaving open kind of what on earth is the court actually answering. And so I think you can interpret this case as a narrowing of the CFAA, or at least a narrower interpretation, but that leaves a lot of wiggle room for the lower courts to figure out exactly what this statute prohibits or not. So on its face, it's a textual interpretation of the word so that goes on forever. But in practice, it's really, I think, a narrowing where the court is grappling with what does this statute mean in a world where we're constantly accessing computers. The court seems to be saying it doesn't prohibit everything, but exactly what it prohibits is not exactly answered in the opinion. And I'll pass it back to you.
Thank you, Orin. I next was going to talk about the religion cases from last term. We've all focused on the shift in the composition of the court, but I think where it's most evident in terms of decisions is with regard to the religion clauses. Let me talk about two sets of cases from last term with regard to religion. The first involved challenges to governor's closure orders to try to stop the spread of COVID. There were actually two rulings at the very end of the prior term. Both came down in favor of governor's orders and against religious challenges. One was South Bay Pentecostal Church versus Newsom. It involved Governor Gavin Newsom as part of his sheltering orders, saying that there couldn't be more than 25% usual capacity, more than 100 people gathered for religious worship. A church in Southern California brought a challenge. It sought an injunction. The district court ruled against it. The Ninth Circuit ruled against it. It went to the Supreme Court on the so-called shadow docket. It was for an emergency order from the court, and the court denied an injunction. The majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. There's no opinion for the court, but Roberts wrote an opinion for himself, urging deference to government officials and taking action to stop the spread of a deadly communicable disease. 2 months later, in July of 2020, you had Calvary Chapel, Dayton Valley versus Sisolak. Nevada Governor Steve Sisolak imposed closure orders, including on gatherings for religious worship. Church of Nevada brought a challenge. Again, 5-4, the court ruled in favor of the governor. The 5 in the majority were Roberts, Ginsburg, Breyer, and Kagan. There was no opinion for any of them. Justice Alito wrote a very angry, sarcastic dissent. And of course, the dissenters also include Justices Thomas, Gorsuch, and Kavanaugh. But everything changed November 25th. A few minutes before midnight, the day before Thanksgiving, the Supreme Court handed down its ruling in Catholic Archdiocese of Brooklyn versus Cuomo. New York Governor Andrew Cuomo had imposed restrictions based on the prevalence of COVID in an area. Where COVID was most rampant was the red zone. No more than 10 people could gather for religious worship. Some Catholic churches and Orthodox Jewish synagogues in Brooklyn brought a challenge. The district court in the Second Circuit ruled against them, but the Supreme Court 5-4 issued the injunction. The 5 in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts, Breyer, and Sotomayor wrote dissents. Kagan also dissented. And then the first week of April, there was Tandon versus Newsom. Part of Governor Gavin Newsom's order was say no more than 3 households of people could gather for religious worship at a time, or for any purpose for a time. So it didn't matter whether they're getting together to watch the Super Bowl or to pray or anything else. The district court denied an injunction to challengers. The Ninth Circuit denied an injunction, and the Supreme Court reversed 5-4 and granted an injunction. The 5 in the majority again were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. What explains the shift from the first 2 cases to the latter 2 cases? It's obvious. It's replacing Justice Ginsburg with Justice Barrett. And the opinion written in Tandon versus Newsom is quite clear that religion must be treated as favorably as the most leniently regulated secular activity, very much limiting governors' powers and very much protecting religion. The other case with regard to religion that I briefly mentioned came down in June. It was Fulton versus City of Philadelphia. Philadelphia relies on private social service agencies to place children in foster care. It requires that they agree not to discriminate based on race, sex, religion, or sexual orientation. Catholic Social Services said it could not agree to that because it could not, based on its religious beliefs, place children with same-sex couples. It brought a challenge. It lost in the federal district court, and it lost the United States Court of Appeals for the Third Circuit. Both of those cases relied on a 1990 Supreme Court precedent, Employment Division versus Smith, which says we don't give exceptions to general laws on account of religious beliefs. Justice Scalia wrote that and said, if it's a neutral law of general applicability, you can't bring a free exercise challenge, no matter how much it burdens religion. The Supreme Court unanimously reversed the Third Circuit. Chief Justice Roberts wrote for the court and said, the Philadelphia Ordinance allows for exceptions to be granted. No exception ever had been granted. Philadelphia said no intention to give exception. There was no discrimination against religion. But he said the existence of discretion to give an exception means it's not a law of general applicability. It has to meet strict scrutiny. So the takeaway is any law that burdens religion, that has any government discretion, is going to have to meet strict scrutiny. Justice Alito wrote an opinion concurring the judgment, it was 77 pages long, joined by Justice Thomas and Gorsuch, urging the immediate overruling of Smith. He said, whenever the government burdens religion, it should have to meet strict scrutiny. Justice Barrett wrote a concurring opinion, joined in full by Justice Kavanaugh, and she said, I'm persuaded by Justice Alito, we don't need to go this far in this case, and besides, there'd be hard questions to answer. I think that this shows a court that is very much inclined to give exceptions to general laws, including anti-discrimination laws for religious beliefs. There's many cases pending now in the lower courts, whether employers can discriminate against gay, lesbian, transgender individuals on account of the employer's religious beliefs. cases about whether or not bakers or florists or videographers can refuse to serve same-sex couples. I think what we now have is a court that's very much going to prioritize religious freedom over anti-discrimination principles. And finally, from last term, Easha, you're going to talk about Torres versus Madrid, which I understand is a case that you were involved with.
That's right. And so I think it's an important case, and I'll try to convince you of that it's not just because I litigated it that I think that. So so here are the facts of the case. Roxanne Torres is in her car in a parking lot. Police officers show up with a warrant for somebody else. They see her in the car and want her to get out. She's convinced they're carjacking her, so she drives away, right? She can't tell that they're police. And the cops shoot at the car as it's driving away. They hit her, multiple bullets strike her, but she keeps driving. She, in fact, crosses state boundaries. She starts in New Mexico, ends up in Colorado before she stops the car. And then she files suit. She says, this violated my Fourth Amendment rights. It was unreasonable of you to shoot me in this circumstance. And the 10th Circuit throws it at the threshold. It says the Fourth Amendment just covers seizures. This wasn't a seizure because you didn't stop. It goes up to the Supreme Court. So the Supreme Court, in a 5-3 opinion, Justice Barrett is not yet sort of fully on the court's shoes and participate in this case. In a 5-3 opinion, the Supreme Court sort of does this kind of ye old common law syllogism. It says the seizure of a person was a term of art at common law. We can see from kind of contemporaneous sources and dictionaries at the time of the founding that was equivalent to the term arrest. An arrest at the time of the founding actually was usually not effectuated by police officers, right? But public police forces weren't really a thing, but often by private individuals to kind of collect a debt. And it turns out an arrest was effectuated if you sort of, lots of quotes that say something like to the effect of, if you but touched the victim with the tip of your finger, they were under arrest. So put these together, seizure equals arrest. Arrest is any kind of physical touching. We've got our answer. So what I think is fascinating about this case, and I'll be the first to acknowledge, right, that the practical effect is limited. I litigate a lot of policing cases, and when police want to stop you using physical force, they usually stop you, right? There's usually not that many cases where there's physical force effectuated, but you're not actually stopped, which is sort of the scenario that the Torres case deals with. But I think this case is important for kind of two reasons, because of what it illustrates about kind of the methodological underpinnings of the Supreme Court's docket going forward. So the first is, and these both sort of have to do with a conversation between the dissenting justices, Justice Gorsuch, Justice Thomas, and Justice Alito, and the majority, which is Kavanaugh, the chief, and the 3 liberals. So the first thing I found totally odd about this case is the dissent has this pretty brutal, or at least the dissent seems to perceive it as brutal, criticism that today's decision is maybe explained by, quote, an impulse that individuals like Ms. Torres should be able to sue for damages. And the majority takes great pains to rebut that. They say there is no call for such surmise, that this is like an offensive thing to say. But would it be so insane if some part of the motivation here was, we think it unlikely the founders would have wanted to leave someone without a remedy in this circumstance, or we don't want to leave someone without a remedy in such a circumstance. So to the extent there's ambiguity in the dictionaries and the founding era case law, that's a tiebreak. And even when I clerked on the court, which was only 5 years ago, I think that would have been a totally acceptable motivation for an opinion. If someone said some part of this, some part of this is motivated by the tiebreak, this is just the kind of thing that this is the way we think it ought to go. That wouldn't have been a sort of a scarlet letter the way it is here. So I think that's the sort of first kind of interesting thing about this case is we're very much in a new era, and it's a sign of a kind of the conservative supermajority that even the suggestion that this kind of policy-ish consideration might have been playing a tiebreak role would be treated as this insult to sort of vehemently deny. That's the sort of first thing I think that's interesting about it. The second is the majority opinion very much follows kind of down to the step in the syllogism, a case called Hodari D that Justice Scalia authored, where he sort of articulated the sort of precise syllogism that the majority follows. And I think again, sort of 5 years ago, Justice Scalia doing originalism and coming to an answer would have been pretty good for most of the conservatives. And Justice Gorsuch's dissent is again pretty vicious about this, the majority's originalism here. He says, the common law offers a vast legal library. We have no business wandering about and randomly grabbing volumes off the shelf, plucking out passages we like, scratching out bits we don't, all before pasting our own new pastiche into the US reports. So I think that's fascinating for two reasons. One is it reads actually like something Justice Stevens would write, not something a Justice Gorsuch would write, right? It's sort of fundamentally the critique that has always been leveled at the originalist methodology, that any application of sort of ye old common law to the present day is of necessity a sort of, quote, pastiche in Justice Gorsuch's words. At the time of the founding, it was private individuals, not police officers effectuating arrests, right? At the time of the founding, it wasn't guns and bullets, right? The Chief Justice's opinion draws an analogy from this 17th century British case where someone is arrested by being touched with the tip of a mace, like, the Queen of Clubs or something like that, right? But these are the sort of problems that we confront anytime we use an originalist methodology to address problems in the modern world. And so to hear Justice Gorsuch kind of lambast this sort of pastiche approach, I think first illustrates the ways in which now that there are 6 justices that subscribe to this majority, it's sort of not enough to have ye old common law roughly on your side, right? There are divisions even within that originalist camp. And second, how things have kind of come full circle. This critique that liberals leveled at originalists for so many years that you're of necessity picking and choosing because there's never going to be a one-to-one application has now kind of come full circle, and we see sort of originalists berating fellow originalists about the ways in which they're picking at random and putting a pastiche into the US reports. So despite the fact that the kind of number of people that I suspect this opinion will make an outcome determinative difference for, it's probably pretty limited. I still think it's a kind of critically important case for what it shows about the kind of ways in which litigants are going to have to argue before the Supreme Court to get any traction going forward.
Thank you so much. Do any of the panelists want to comment on anything that's been said by the others before we move to October term 2021? Orin.
Yeah, I wanted to respond on Torres because it really is a fascinating case. And I agree with Easha about a lot of it, in particular, the sort of oddity of the justices being astonished that they might just be going a particular direction because they thought it was the better direction to go, which was presumably driving the majority. And so that was an interesting dynamic. I mean, I agree that if you're briefing, especially a Fourth Amendment case before the U.S. Supreme Court, you better be talking about history, and you better be talking about Hawkins and Blackstone and Cook, and you better be steeped in 1791 and be talking about that a lot. It reminds me of VanBuren also, where this sort of it's textualism. On its face, it's very textualism, and Torres on its face is very much originalism. I kind of think that the history was a lot weaker in Torres than the majority let on. Because of the context in which the issue arose, it was mostly in civil or criminal prosecutions for escape. So there was this whole private system of detaining at common law, and what they didn't want you to do is like arrest someone, which you were required to do if you're the night watchman, and then let them go. And they would call that an escape if you just touched them and let them go and said, really sorry, I couldn't hold on to them. And they were like, no, you've got to hold on to them once you grab them. And an arrest was an element of the escape tort and crime. And so like what an arrest meant at common law, I think, was like really, really different. And it raises a lot of conceptual questions about how you apply that common law concept to a modern world of searches and seizures. And I think there was a lot, I think Justice Gorsuch was fair in pointing out that, like, yeah, there is a shift in perspective here. And to my mind, the ultimate sort of direction, Easha may share some of this, is like, this suggests you shouldn't over rely on originalism in trying to draw these conclusions, because you've got so much flexibility. Probably the work is going to be done by something else. But at least from an advocate standpoint, I think absolutely we're gonna be in a world where, part one in 1791, this was the meaning of the term, and so you better know your English legal history And I taught a seminar on originalism for first years, in part because I've been doing a bunch of originalist or really historical work in criminal procedure, because I think that's going to be the direction of a lot of the field for the foreseeable future. So it's not where I think a lot of law professors would want to go, but it maybe that's where the law is really going to focus.
And I should say, all credit to Professor Kerr, who was gracious enough to talk with me as I was litigating the case, raised a lot of these concerns, and maybe to his chagrin, enabled us to kind of combat some of them in the briefing. But I think that's absolutely right. I just argued a case at the Fifth Circuit on behalf of someone who's been in solitary confinement since 1994, and I opened with, at the time of the founding, solitary confinement was considered a fate worse than death, right? That's not what's motivating me to take the case. But that was the first line. And I didn't mention once the sort of what psychologists have said in the centuries since, the ravages to his mental health. It was all about, this was the practice at the time of the founding. Solitary confinement was considered this really terrible punishment. This is the original meaning of unusual and what's happened in centuries since. All my support by way of amicus briefs came from historians. So I think on that, at least we very much agree.
I also think, yeah, I love this discussion about Torres, which I think is a fascinating case, and wanted to tie it back to my remarks at the beginning and just note the way that instead of talking about unreasonable searches and seizures, which are capacious terms that we can probably have reasonable views on, right? We're indulging in this methodology that requires Easha to sort of open her statement within 1791. And that's precisely this sort of technocratic specialized expertise that Bowie is pushing against, right? This idea that we have to understand, well, Koch and Blackstone to understand, and cite back to these sort of documents and cases from 1791 to understand that shooting somebody is an unreasonable seizure. And it seems like this is precisely this sort of discourse that takes this out of the realm of the common, out of sort of commonplace deliberation and discussion, and elevates it to a space where very few people can have this conversation. And that really is court empowering.
And one kind of final point on that, Professor Chacón, that your remarks made me think of is just what I've noticed is it's a really labor-intensive methodology, right? If you are a public defender or anyone who has a high volume of cases and doesn't have just like a ton of time at your disposal, it's really actually very hard to build an originalist argument, right? Like, we have the luxury at MacArthur, we have a lot of students and a lot of fellows, law firms have a lot of associates, but if you are the average civil rights practitioner or public defender or what have you, who has a high caseload, who doesn't have a ton of people working under them to scour, Blackstone, or, look at a lot of sources that aren't fully digitized or read a lot of primary texts, it's an enormous undertaking. And so I do think that's another way in which, to your point and to Nico's point, Nico's my co-clerk, so I feel comfortable saying just the first name, that it sort of becomes rarefied, not just to the legal profession, but to particular segments of the legal profession that have an enormous advantage because their resource advantage translates so directly into an advantage when the terms of the discourse are solely around what happened in the 1790s.
Let's move now to talking about October term 2021. It starts a week from Monday, the first one in October, October 4th. And I'll ask each of the panelists to take 5 minutes to take a case and describe it, and that'll then leave us 10 minutes at the end for questions. Orin, you're going to talk about the major gun case on the docket.
I am. So this is New York State Rifle and Pistol Association versus Bruin, which will be argued on November 3rd. And the question in the case is whether a denial for an application for a concealed carry license for self-defense violated the Second Amendment. So the Second Amendment is, of course, the right to keep and bear arms. And for most of American legal history, it was not doing very much at all, if anything. And then in 2008 in DC versus Heller, the U.S. Supreme Court, in a 5-4 vote, concludes that it does give an individual right, whatever that right is, and it is rooted in self-defense. and applied in the context of Heller in the context of the home. And then in 2010, in McDonald versus City of Chicago, the Supreme Court again divides 5-4, saying that the Second Amendment right is incorporated and applies to the states. And so since 2010, there has really been nothing. I mean, there was one per curiam decision in 2016, Caetano, which was fairly minor. But really, since 2010, what the Second Amendment means has been up for grabs, and the U.S. Supreme Court has not taken another Second Amendment case for argument, much to the frustration of Second Amendment advocates who keep teeing up cases and trying to get the Supreme Court to explain, okay, back in 2008, you said there's this right, and we're looking at the clock and it's 13 years later, and you haven't said what this means. And usually when the Supreme Court will recognize some sort of a right, within 5 or 10 years, there's a group of cases which say what it means. And we haven't had that in the Second Amendment setting until now. And so the Supreme Court took this case. Why did it wait until this case? A lot of speculation as to maybe the justices who favor strong Second Amendment rights were waiting for a clear majority to go in the direction that they wanted to go in, and with the current conservative 6-3 court, that they probably have the votes to do so. But the argument that is made by the New York State Rifle and Pistol Association, represented by Paul Clement, is that the Second Amendment right applies to the carrying of arms outside of the home for self-defense. The brief filed on behalf of that side, all sides, very steeped in history, all trying to make sense of what is the historical right to carry arms. Did it apply outside the home? What were the rights traditionally outside of the home to carry a gun? And the brief filed by the petitioners in the case, again by Paul Clement, basically says this is a core constitutional right. The Second Amendment, the meaning of carrying a gun, has traditionally in American history meant you can carry it outside of the home, and that New York's licensing system, which basically gives the discretion of whether to give a concealed carry license to any applicant to the discretion of the government official, does not allow people their constitutional rights to carry guns and to get this concealed carry permit outside of the home. I suspect, and I think this is probably the common wisdom, to the extent there's ever a common wisdom on where the court is going, that the Supreme Court will find this a pretty appealing argument and will agree and will reverse. And it's, partially reflecting the framework and the context from which the majority of the justices are coming from. On the conservative side, Second Amendment rights are considered really foundational or considered incredibly important. And so there's this thought of, well, we've got the Second Amendment right. It has to mean something significant. And it's not just limited to having a gun inside your home in case somebody comes inside your home, but includes being able to protect yourself with a gun outside of the home. And so that, to the extent we have a polarized nation where this claim is going to seem intuitively obvious to half the country and astonishing and outrageous to the other half of the country, where the justices are, I think there's a majority of justices with the view that that's kind of an intuitive idea and reflected in the history of carrying guns in the United States, that's going to be something that they see as part of the Second Amendment. But the real question here is is the Second Amendment right one that goes outside of the home, or is it just limited to the home? And that's the big question at stake. I'll pass it off.
Terrific. Thank you. The next case we were going to talk about from the coming term, I was going to discuss, and that's Carson versus Macon. That's going to be argued on December 8th. It involves the religion clauses. For so many decades, the issue was, when may the government give aid to religious schools without violating the Establishment Clause? There were cases about, can the government, if it wants to, provide sign language interpreters or buses for field trips or textbooks or audiovisual equipment without running afoul of being an establishment of religion? Now the issue is very different. Now it's, when must the government give aid to religious schools, or it's violating free exercise of religion? And we first saw this in 2017 in Trinity Lutheran versus Comer, the state of Missouri program providing aid to schools for surfacing playgrounds. The state provided it to public and secular private schools that qualified, but wouldn't do so to religious schools because of provision of the Missouri Constitution that outlawed direct or indirect government aid to religion. The Supreme Court 7-2 found Missouri violated free exercise of religion in denying the aid to religious schools. Chief Justice Roberts wrote for the court. Justice Sotomayor wrote the dissent, joined by Justice Ginsburg. Justice Sotomayor said, this is the first time in history that the court has ever said the government is constitutionally required to give aid to religious schools. Chief Justice Roberts, though, said this was a very narrow case. In footnote 3, he said, this is just about aid to playgrounds. But we know that's not how cases work in the Supreme Court. In June 2020, in Espinoza versus Montana Department of Revenue, the Supreme Court more broadly said, whenever the government gives aid to secular private schools, it must give that aid to religious schools unless doing so would violate the Establishment Clause, unless the government can show its action is necessary to achieve a compelling purpose. Espinoza involved the Montana law that gave a tax credit to those who provided money to a private school tuition organization. Most all of the private schools in Montana are religiously affiliated. The Montana Supreme Court said that this violated the Montana state constitution, which also prohibited direct or indirect aid to religion. I would have thought this would have been the end of the matter, as it was a state Supreme Court saying a state law violated the state constitution. But the Supreme Court 5-4 reversed Chief Justice Roberts writing for the conservative majority. And Chief Justice Roberts said, as I mentioned, whenever the government gives aid to secular private schools, it must give that aid to religious schools, unless doing so would be an impermissible establishment of religion, and very little violates the Establishment Clause for this court. Well, the case Carson versus Macon comes out of Maine. There are parts of Maine that are too rural to support a public school system. So in those areas, there are school administrative units that provide funds to parents that they can then use to send their children to private school. But Maine says it cannot be used for sectarian private schools. In other words, it must be used just for secular private schools. A couple of parents, a couple of religious private schools have brought a challenge to this. On the one hand, perhaps the court will see this as different than the other cases. The other case involved so-called Blaine amendments, amendments that had been required for statehood in the 19th century that had a strong anti-Catholic bias. The Maine constitutional provision in Maine law has nothing to do with that. Also, this is a situation where what the state is trying to do is provide for education, much like a public school education, which would be secular. On the other hand, Trinity Lutheran and Espinoza say, whenever the government provides aid to secular schools, it must provide it to religious schools, and Maine is violating that principle. I think we have a court with probably 6 justices who want to very much increase allowing the government to provide aid to religious schools, increase the ability for religion to be part of government. And so my guess is the Supreme Court here will rule against Maine. And Easha, you were going to have a criminal case from the docket.
Yeah, I think I'll kind of quickly touch on 2 cases because I think there's interesting cases that where the United States asked the Supreme Court to get involved before the change in administration, but they're going to stick to their guns. And I think it's just sort of a interesting framing around the kind of stated progressive priorities of the Biden Department of Justice and the sort of real institutionalist imperatives. The first is the Jahar Tsarnaev case, the Boston Marathon bomber case. He's convicted and sentenced to death in Massachusetts. And the First Circuit reverses the penalty, the death penalty part of his conviction on 2 grounds. First, that the district court should have allowed the defense attorney's requests to kind of question jurors further about media exposure. And second, that the district court should have allowed in evidence of prior murders that Tamerlan Tsarnaev, Jahar's older brother and co-conspirator, that he previously committed to kind of show that he played the greater role in the charged crimes. The second case that's kind of in that category is a case about the state secrets privilege. So Abu Zubaydah was subjected to the enhanced interrogation program. So things like exposing him to insects to take advantage of his entomophobia, waterboarding, mock burials, so on. He files this criminal complaint in Poland, seeking to hold Polish officials accountable. In order to assist Polish authorities, he files an application in the United States under a statute that lets the district court issue subpoenas for information that will be useful in foreign proceedings. And the government invokes what's called the state secret privilege, and that's so kind of even though virtually all the information in question is in the public record somewhere. And so I think both of those cases kind of tee up interesting questions about how the Biden administration and the Biden Department of Justice, which have sort of publicly taken far more progressive positions than even Democratic administrations in recent years, will kind of balance their sort of competing imperatives, right? So in the case of the death penalty, AG Garland decided to halt all executions pending study. In the state secrets case, as vice president and sort of since Joe Biden's public statements kind of lauded the Senate report exposing this interrogation program, called it a quote, badge of honor that the United States had publicly grappled with that stain. And so I think that I don't think anyone who's familiar with the works of the Department of Justice is surprised that the Biden department is maintaining their position, right? These are kind of core to the function of the Department of Justice is the ability to preserve a conviction and the ability to hide information when they want to hide it. But I think we're going to sort of see a greater and greater tension between a department and an administration that has taken great pride in staking out really, really progressive positions. And the sort of tension between that and the real institutionalist imperatives to preserve the power of the department and of the government to disclose only what they want to disclose, to get the convictions they want to get, and so on. And so those are two cases I'm watching only because I'm kind of curious to see how they play out in the kind of court of public opinion, what the Biden Department of Justice says, and what sorts of positions they might take in the court that might sort of thread that needle.
Terrific. Jennifer, you were going to talk about what's undoubtedly the most high-profile the most high-profile case of the term, abortion rights.
And I muted, so that's very fitting, right? So I will be talking about Dobbs versus Jackson Women's Health Organization. Arguments are scheduled for December 1st. And this case is obviously what Professor Kerr would have labeled one of the culture wars cases, right? And I think we all have seen the public attention to it. So Mississippi in this case has specifically asked the court to overrule its landmark decisions in Roe versus Wade and Planned Parenthood versus Casey. So this is not a sleepy case. This is one that a lot of people are watching. So by way of background, Roe is the case that sort of articulated the 14th Amendment right to abortion access, subject to possible limitations later in the pregnancy. And the 1993 case of Casey outlines the currently operative constitutional standard, prohibiting states from imposing an undue burden on abortion access prior to fetal viability, which is probably about 24 weeks, give or take. As the courts moved to the right in a series of successive replacements of justices over the years, Casey has faced a number of challenges. So in 2016, in a case that Erwin's actually already talked about, reproductive health service providers, Whole Women's Health actually mounted a challenge to a Texas law that placed requirements on abortion providers and clinics that would have shuttered almost all of the clinics in the state of Texas. And the Supreme Court struck down that Texas law in a 5-4 decision applying Casey. Justice Breyer delivered the opinion for the court with Justices Kennedy, Ginsburg, Sotomayor, and Kagan joining, and the 4 conservative justices dissented. Then, as you'll recall, Kennedy left the court in 2018 and was replaced by Justice Gorsuch. Louisiana liked its odds given this new configuration, and it had enacted a law that was functionally identical to the Texas law that was struck down in Hellerstedt. That Louisiana law was challenged in June Medical Services versus Russo, and to the surprise of some, the court again struck it down last year on a 5-4 vote with Chief Justice Roberts joining the liberals. but doing so through a concurrence that notably and significantly raised the bar on what would be required to demonstrate an undue burden going forward. Then in 2020, Justice Ginsburg died and was replaced by Justice Barrett. So now, really liking its odds, Mississippi and a number of other states has enacted a highly restrictive abortion law. With limited exceptions, this law bars abortions after the 15th week of pregnancy, which is significantly before the viability line that was articulated in Casey. It would be pretty difficult for a way to come up with a sort of legal way to distinguish Casey, and the state really isn't trying to. So this petition comes with that sort of explicit request that the court overrule that precedent. And the votes seem to be there to do it. Indeed, we can see that in some ways, Roe and Casey have already been functionally overruled, at least in Texas. So just a few weeks ago, the court declined to block enforcement of a Texas law, SB 8, that rewards any person a minimum of $10,000 for suing abortion providers or those who aid and abet the performance of an abortion after roughly the 6th week of pregnancy. And that was the case of Whole Women's Health versus Jackson. So at the moment, while the litigation in Dobbs continues and while the litigation in Jackson continues, abortion is functionally illegal after 6 weeks, well before viability in Texas. And the Supreme Court didn't weigh in to explain its sort of decision not to weigh in on that matter. So regardless of how the Dobbs opinion is written, it seems pretty clear that state legislatures are going to have tremendous power to restrict abortion after the decision. And so that's where we are now.
Thank you, Easha, Jennifer, Orin. You were each terrific, and also we stayed within the time, so we have time for questions. So I appreciate that. Please put your questions in the Q&A. I've seen a couple of questions so far, so I'll pose in the panel. The first is with regard to the so-called shadow docket, matters that come to the Supreme Court for emergency rulings, to grant injunctions, to stay injunctions by lower courts. Has there been a change in the shadow docket as asked? Or maybe I can rephrase the question posed more as, what are your thoughts about the shadow docket, which has now gotten so much public attention?
So I can start and just say a couple of things. The first is, yes, there's been a change to the shadow docket. And again, a change even in the 5 years since I clerked. It is much, much more active. So I'll highlight sort of one high point and then one sort of low point and then one sort of high point if you're kind of a progressive advocate. So one way in which the shadow docket has changed is, you know, it used to be that there were certain categories of cases where the Supreme Court really felt like, for better or worse, like they had figured out the law. So arbitration, EDPA cases, which are sort of habeas cases, qualified immunity. They had a view. It was not a progressive view, but they had sort of a consistent view they were applying to cases, and sort of cases that were in that bucket were likely to come up and get summarily reversed. The category of cases in which they're issuing these sorts of summary reversals has gotten much broader. So it sort of peaked with the New York eviction moratorium. So separate from the federal eviction moratorium. This is the New York state eviction moratorium, where the Supreme Court granted an injunction against this state law and did so based on, I'm quoting the text here, based on, quote, the longstanding teaching that no man can be the judge in his own case consistent with the due process clause. I think even a lot of folks who agree with the kind of politics of the outcome were just like genuinely puzzled by this longstanding teaching that no one seems to have heard of. So I would say they're getting much bolder in sort of the chunk of cases. So it's, the shadow docket has historically been one-sided, right? The kinds of cases the Supreme Court thinks are easy enough to resolve without briefing an argument have historically fallen on the kind of conservative side of the spectrum. But the sort of breadth and the number of cases in which this is happening, I think, has gotten much broader. I said I'd say one high point about the shadow docket. One kind of historical thing about the shadow docket is this year was a banner year for a certain set of civil rights practitioners because, as I mentioned, historically, the Supreme Court has always used the shadow docket to reverse cases where lower courts had the audacity to deny qualified immunity. So to say that police officer or prison official, you are going to go to trial. And this year, for the first time since October term 2013, if I'm not mistaken, the Supreme Court, in not just one, but I think 3 different cases, used the shadow docket to correct an error where a lower court had granted qualified immunity. So it started with a case called Taylor versus Riojas, where a prisoner was kept in a cell covered with feces. And the Fifth Circuit said, he was kept in a cell covered with feces. We've said you can't do that for 2 months, but here it was just 2 weeks. And so, no prison official could have known that. Qualified immunity. The Supreme Court was like, some principles are just so obvious you don't need a case kind of squarely on point articulating them. And there's 2 others in that category. So that's one respect in which, the kind of historical role of the shadow docket to make sure that police officers and prison officials were protected seems to have reversed course this year. And I have no thoughts about whether that's a long-standing, a long-term reversal or just sort of a coincidence this year.
Orin, Jennifer, your thoughts on the shadow docket?
So I'm happy to offer a thought, which is especially on the emergency application side of the shadow docket, because shadow docket can mean a bunch of different things, and I'm going to focus on the emergency applications, requests for preliminary relief, and the like. The Supreme Court's new reliance on that should remind us about how important the traditional procedures are governing Supreme Court decision-making for limiting the role of the Supreme Court, sort of requiring the regular procedures. It takes many years for an issue to get up to the justices. Usually they're looking for some sort of circuit split, and that is going to slow down the Supreme Court, and it's going to channel them into certain kinds of cases, and everything takes a really, really long time. And if you can rely on emergency applications to issue decisions, you can get a case up to the Supreme Court in 2 weeks. It's like just boom, just keep moving and keep moving and keep moving, and suddenly you've got an emergency application. And traditionally we a lot of conservative critiques of, for example, the Warren Court were based on the sort of failure to follow regular procedures, asking for briefing on a different issue in a case like Mapp versus Ohio, and sort of being in a rush to go places. And this is, I think, now the tables are turned. Now it's the conservatives that are in a rush. It's not Justice Douglas trying to stop the Vietnam War by enjoining the Vietnam War himself. It's the court getting these emergency applications and handing down decisions on major issues with hardly any explanation. And so really to the extent that a lot of conservative legal thought was based on a rejection of what the Warren Court did, we're seeing a lot of similarities here on the shadow docket with what used to be criticized.
Jennifer?
Sure. I was just thinking of one case where it was the sort of case where I thought the Supreme Court would intervene in Texas versus Biden, which is the case involving the so-called Migrant Protection Protocol, or MPP. And the MPP program was something that began under President Trump and required that migrants arriving at the southern border requesting asylum remain in Mexico. Non-Mexican asylum seekers remain in Mexico until their hearing date. There were lots of challenges to the legality of MPP, but it actually became sort of significantly less important with the arrival of COVID, because that's when the Trump administration pivoted to reliance on Title 42, which is a sort of public health ordinance, to kind of have the same effect, right? Turning people away at the border who were seeking asylum. And so the MPP program really, once Title 42 went into effect, wasn't doing much work. And the Biden administration came in, and due to the challenges, legal challenges to MPP and the extensive sort of evidence that this was kind of deadly and dangerous policy for asylum seekers, the Biden administration issued a fairly lengthy memo explaining why it was going to rescind MPP. And the rescission of MPP was then enjoined by a federal district court in Texas, and that injunction was upheld by the Fifth Circuit. And this is one area where you would think, given that foreign affairs are involved, given that this relies on negotiations with Mexico to carry it forward, given that the program actually wasn't really operative, and this is requiring the administration to start up a program again, negotiate with Mexico to start up a program again. This seems like the sort of zone where you wouldn't expect the injunction to hold, where you might expect the Supreme Court to say, look, this is a delicate foreign policy question. This is one where the executive has tremendous authority, and an injunction isn't appropriate. Or sorry, the kind of requirement to restart the program is inappropriate, and there the court declined to act. So I think we see, not just sort of urgent actions on the part of the court that short circuit procedures, but we also see sort of puzzling inactions in some cases where we might have previously expected something different.
The one thing
okay. Sorry, Dean Chemerinsky, go ahead.
Oh, go ahead, please.
Oh, I was just going to say that, and Professor Chacón, as you pointed out, the Texas abortion case is such an instance, right, where the Supreme Court sort of says this is so procedurally complicated we couldn't possibly wade in at this junction, while on the other hand, kind of reaching out to resolve really thorny and not at all clear legal questions in other contexts. So to your point about inaction as much as action being the kind of hallmark of the shadow docket, and the contrast between the cases where there is dramatic action and when there's dramatic inaction.
The point I was going to add about the shadow docket was how the Supreme Court is not following traditional principles of appellate review in deciding whether to grant an injunction or reverse an injunction. In the appellate courts, an injunction from a lower court should only be overturned, stayed for an abuse of discretion. The denial of an injunction should only be overturned for abuse of discretion. And that really matters in the federal courts of appeals. It doesn't seem to matter in the United States Supreme Court at all. So I think of the instance where Congress refused to appropriate money for the border wall. President Trump said, I'm going to spend defense money on it anyway. Federal district court issues a preliminary injunction. The Ninth Circuit allows it to stand. And then the Supreme Court stays it without a finding that it was an abuse of discretion. Or there was an example with regard to the Wisconsin primary a year ago, March, or a year ago, April, where a federal district court says we're going to extend the time for absentee ballots, issuing a preliminary injunction. The Seventh Circuit allows it to stand. The Supreme Court should only be able to stay that for an abuse of discretion, but pays no attention to the standard of appellate review. And that's, I think, a significant problem with how they're using the shadow docket. There's another question that we've gotten that relates to the president's commission on the Supreme Court and whether it's likely to lead to any meaningful reforms. Jennifer, maybe I can start with you because you began the discussion this morning by talking about it.
Sure, you can start with me, but I have no crystal ball. My sense of the commission is that it was meant to diffuse sort of a nascent political conversation on the left about the need for sweeping court reform, court packing, et cetera. And that Biden did what politicians often do, which is say, let's put together a commission and we'll study this and we'll have recommendations. And I suspect there will be recommendations, but I would be surprised if any of those are particularly sweeping or notable. I don't think there's going to be, I don't think the result of this is going to be additional seats on the Supreme Court. I think there may be, attention to lower and appellate courts and staffing, but I just think that what this was designed to do was to diffuse a conversation, and that is probably, given the composition of the commission, given the sort of length of time they're working on, that is the likely outcome of the commission's work. Maybe other people have a different take on where this is going.
Orin or Easha?
I agree. I think that's right.
One of the questions is in terms of the proposal to increase the size of the Supreme Court. And it could be done by statute, but given a Republican filibuster in the Senate, I don't see any possibility of it happening, and nor has President Biden or Speaker Pelosi indicated any support for it. Let's conclude, even though we won't get to all the questions. I want each of you to have, it can only be a minute because we're out of time, but if you could each take a minute and offer whatever thoughts that you have as concluding remarks. Easha?
So I'll just say, thank you again for having me. And maybe sort of my one concluding thought is for folks who are practicing, who are recent graduates, who are sort of thinking about how to make change in a world with the Supreme Court, which is going to be the Supreme Court that we'll have for a generation, as Dean Chemerinsky noted. I think one of the things that the civil rights community is doing and is long overdue is starting to think about pivoting to state courts and state constitutions, right? Those are fora that in a lot of places are more progressive than their federal counterparts. They're also fora that can change much more quickly. Terms are shorter, often justices have to be elected or reelected or can be reappointed by a change in administration. State constitutions have sort of long been neglected as a source of civil rights, despite the exhortations of justices going back to Justice Brennan. And so at the MacArthur Justice Center, we're sort of launching a project to kind of state constitutional project to try to think about where we can go and what we can push going forward, because we see so many of our victories getting snatched away at the Supreme Court level. And as I suppose my concluding thought is a sort of depressing one, which is Professor Chacón pointed out that the idea of the Supreme Court as like the harbinger of civil rights has always been a flawed notion. It's particularly flawed kind of today in this day and age. And so as much as anything, we should be thinking about not just the Supreme Court, but where we can go where the Supreme Court can't interfere with what we're doing. And one immediate answer is state courts and state constitutions.
Thank you, Jennifer.
So yeah, I guess I would say buckle up. It's going to be a wild ride this term. I think, and I agree with Professor Kerr that it will, on the hot button issues, I think we all have a pretty good sense of where things are going. And there are lots of sort of interesting, not hot button issues that will reveal a lot about the different and particularly the newer justices. So that'll be interesting to watch. And I guess the final thing I'll say is, I think it's important for all of us who are riveted by the highly technical and the arcane and the precise to also engage the broader world when it comes to sort of thinking about the conversation around law and making sure that we're not holding conversations with. One of the things I always appreciate about Dean Chemerinsky, the way he makes law and constitutional law accessible to everyone. And I think it's really important that these conversations are broadly inclusive, not just of lawyers who are willing to get up on a Saturday morning, but of everyone, and that lawyers are listening and in robust conversation with people who are doing the work in the streets every day and who are experiencing the harsh end of the law every day. So that's the work I think that lies ahead.
Orin?
Thanks for including me in the panel. I just wanted to add, since this is a law school reunion event, there are really interesting questions raised by the topics today of the role of law schools. And that could be the role of law professors writing their scholarship. What do you do when the Supreme Court is quite far from where the scholarly world is in a bunch of different ways? What do law students do when they're studying law when the Supreme Court is in such a different place than at least many, especially at a place like Berkeley, would be? And so I think it is a challenge, I think, for law schools across the board and for law faculty of how to respond to that. And state courts is one answer. I think Easha's right that that's a really productive area. Political reform is a productive area, especially at the state level. But the traditional national federal focus on the U.S. Supreme Court is more of a challenge now than it used to be.
I simply want to say, Easha, Jennifer, Orin, you were each terrific. Thank you for doing this. I want to say, come back next year to the reunion, which will hopefully in person, and we can then review the cases that we've talked about that are on the docket for this term, and so many more blockbusters to come in October term 2021. And we'll now take a break in the reunion activities, and I'll be back at noon Pacific time to do my annual State of the Law School address. Thanks all for coming, and again to the panelists, thanks for a wonderful presentation.
Thank you.
Thank you.
Bye, thank you.